All right, welcome everybody to one of our series of classes, of our mock law school classes. We've been really excited to bring to our prospective students and our accepted applicants a series of mock law school classes where you get a chance to meet our first year professors as well as some of our adjunct professors and kind of get a sampling or a taste of what law school is like. So my name is Diane Steel. I'm the Director of Admissions with the law school. And I am, myself and Francisco Rosas are pretty much your first point of contact as you apply and begin the process to become a law school student and obtain your Juris Doctor degree. So we will be remaining on the call after 1 o'clock. If you have any questions whatsoever for us, we will be staying on the call to answer your questions. I'm really excited to bring to you today our Professor of Contracts, Dean Atkinson. He also is your academic dean. Prior to joining our faculty in 2010, Professor Atkinson practiced general litigation with a Fresno firm that you may have heard of called McCormick Barstow. And prior to that, after that, he was county counsel, and his focus was civil litigation with an emphasis in public entity liability. His practice included extensive motion and trial work as well as appellate work at both the state and federal level. We are so excited to have him on our faculty as well as serve as academic dean. So I'm super excited for you to meet him on this call today. So I'm going to go ahead and turn it over to Dean Atkinson. And please, Dean Atkinson, feel free to introduce yourself and take it over from here.
Hi, everybody, welcome. Thank you, Diane, for that introduction. I'm glad to see many of you here. Hopefully, I can give you a taste of what at least my contracts course would be like. I handed out, so I actually had asked Diane to send out some materials for today's class. I'm not sure if you were able to get those and read some of those, but I wanted to kind of make this as close to a real class as I potentially could. So we'll see how that works. Now, what I generally do is, you as students will come to class having read cases, and we walk through those cases together. It's called the Socratic method, and I kind of ask you questions and I answer questions. But what we don't want to happen is for us to just lecture at you like I'm doing now. I don't like to lecture. I like to have a lot of interaction. This is the way they kind of learn law. And when you practice law, this is the way you practice law. You have an interaction with the court, with clients, those types of things. So it's never really any lecturing involved. And we'll have to limit that by having kind of a participation in class. So I'll ask many of you to participate. Now, generally in my class, I will just call on you, but it's nice. Everyone's friends. We're all at the same level, right? So hopefully when I call on you, you'd feel comfortable answering questions or just helping me walk through these types of cases. But for today, I'm going to ask for volunteers to help me through this to make it a little easier and see if, how many of you have read, and if we can walk through these cases so I can give you an idea of what this contracts course would be like. So if you have a chance, grab those cases that I sent you, and we were going to start with Hawkins versus McGee. And this is what you would get in class. I'd say Hawkins versus McGee, open your book, and I would say, Miss so-and-so or Mr. So-and-so, what are the facts of this case? How would we start? What are the facts of this case? So anybody who's read Hawkins versus McGee, and I know that it's a contracts case, right? So it might not be as fun as a torts case, or might not be as fun as a criminal law case, but hey, contracts can be fun. And I think this is, I love contracts. I'm the contract professor, so maybe this could be fun for you as well. But what are the facts of this Hawkins versus McGee case? What am I talking about when I ask you what the facts are? Any volunteers here? You can do it. Just come with me. We'll go on a trip together discussing these facts. Anybody?
We do have Kaylee and Mark raise their hands. So anyone like to elaborate, please?
All right, let's go. Who raised their hands? I'm sorry.
Kaylee?
Kaylee, go ahead. Tell me what the facts are, Kaylee. I can help you.
Sorry, it took me a second to.
Oh, there you go. I got you.
One thing that stood out to me when I was reading it, like on the first page, was that opinion does not equal like liability,
Opinion does not equal liability.
contract liability.
Okay. Now, Kaylee, why don't you tell me, when we talk about facts, I think one of the most important things about contract law is we figure out what the beef is, right? And we want to know from the start, what is the issue we have here? And mainly, like maybe who the parties are, what the question is, what is the problem? What's the beef here? Can you tell me that?
I think it's about how the doctor, the surgeon, set guaranteed that he'd fix his hand 100%, like it'd be 100% back to normal.
Okay, so one of the parties is a doctor, right?
Yeah.
Does everyone see what I'm writing here?
No, on my screen it's just a small little line.
I've shared my screen. Is that possible, Diane? And
Yeah, a minute ago it showed your entire screen, but for some reason it narrowed down. I'm not sure. There, now it's white again. Whatever you just did, Professor Atkinson.
so you can see this now. Okay. Let me see if I can get this to work here. This is why in person is so much better, everybody.
Mhm.
I don't know if this is going to let me work this here. Well, we'll just do it without this. It doesn't appear to let me write on this. So we'll be
And
in person.
Professor Atkinson, sorry to interrupt, but you also have a few hands up. Sarah has her hand up, and Ed has his hand up, and I think there's one more. Let me see.
Okay, we're gonna see if I can figure out this. Can you see that now? Is that okay?
Yes, I can.
Everybody, can you see this? See what I'm writing?
Yeah,
Says
I can see it.
Okay, so we got the one party is the doctor, right? Who's the other party, Kaylee? The Kaylee I was talking with, it was, right?
Mhm.
Okay, who's the other party?
It's George Hopkins.
So we've got Hawkins is a patient, right? Right. So we've got a patient and we've got a doctor. Okay. Now, what's the original? What do you think the agreement is? What did the doctor agree to do for the patient?
To skin graft his hand, if I'm correct.
Okay. So doctor. So right now, I'm going to make this arrow here. Doctor promised something. Okay. Doctor promised at least to do this surgery, right? And patient, in exchange, is probably promising some money, correct? Now, generally in contract law, what we're talking about is an exchange of promises, right? So like, I promise to wash your car and you promise to pay me $20. Now, when we exchange those promises, that's what's called a bilateral contract, and a contract is formed. So what's going to happen if, for example, I don't pay you or you don't wash my car, right? That's called a contract breach. So right now, let's set this up. We've got a patient promising money, doctor promising surgery, right? Okay. Now, what happens? Does the doctor fulfill the surgery? Let's see, Sarah, you've got your hand up there. Does the doctor fulfill the surgery?
The doctor does fulfill a surgical procedure.
Does this, okay.
Yeah, so he skin grafts from the chest, removes the scar tissue from the palm, and completes the graft with the understanding that the end result should be better function of the hand, less pain than what the young man had.
Okay, so how do we know what the promises are here? I mean, let's talk about that. So if it's just a surgery, how do we know what the promises are here that doctors promised? Sarah?
There was a verbal exchange, according to the plaintiff. I think it was him himself, his father, and the physician. And they even kind of claimed that the physician was kind of reaching out to them, soliciting, trying to get their business because he wanted to experiment with some skin grafting.
So we know, as you said, the doctor takes the patient, does the surgery, takes some skin from the chest, I believe, puts it onto the hand, right? Mm-hmm. And what happens? Does the case tell you what happens to this hand?
Let's see. through my reading, I didn't see a ton on that. I went and looked and did some further research and read that the patient eventually had chest hair growing out of the palm of his hand. So it's called the hairy hand case.
The hairy hand case. We've got a hairy hand. So let me ask you this. What was the patient promised?
That his hand would be, I think the physician said, perfect or a good functioning hand.
A perfect or a good functioning hand. And what did the patient get?
Pain and a hairy.
A hairy hand, right? So we got a good functioning hand versus a hairy hand. Now, I want to talk about a little bit. I like to use this case because we talk about a couple of things. The first thing I like to use it for is to discuss a potential remedy, which are called expectation damages, right? Okay. Another reason why I like to use this case is to talk about the type, how we view language in contract law, right? So if you go back to what you mentioned earlier, Sarah, you mentioned for me some language that went back and forth, right? So what is that language? If you look at in your case, you see that the doctor. Okay, so who else wants to give this a go? What's that language look like between the parties?
Professor Atkinson, can you hear me? On my screen, all I see is big white with the word doctor. I don't know if you've written more or if
I have, yes.
Okay, I don't know, maybe you want to just verbally do it because we aren't seeing what you're putting on there. Sorry.
Great. That's okay.
Yeah.
Thank you. So I had my arrows there. Okay. Now, looking at this case, okay, going back to how do we know what was promised, right? How is it that we know what was promised? Let me ask you this. This is called the objective theory of contract. So let's say I'm gonna contract with Diane, for example, right? And I say, Diane, I'm offered to sell you my car for $4,000. Okay. And Dan says, okay, I accept for $4,000, right? But in my mind, I was actually thinking to myself, no, I'm really going to sell it to her for $6,000. Okay. So in my subjective mind, I'm thinking I'm going to sell it for $6,000, not $4,000. But I only said to her $4,000. What do you think is going to control and why? Now that I can't write this. Will it be my objective manifestation to Diane that I'm going to sell the car for $4,000, or my subjective thoughts that it's going to be $6,000?
Was actually said.
What I actually said. Why is that, Sebastian?
Well, you have to have a mutual agreement, and if you're thinking one thing, another person can't read your thoughts.
Another person can't read my thoughts, exactly. So
your intentions have to be verbally or in writing so that two parties can agree to those terms.
Perfect. I have to make an objective manifestation of what I want. And that manifestation is going to be judged by a reasonable person standard. A reasonable person standing in that position, what will they think? So in this case, you have on that first page, you have the doctor answering a question. This question: how long will the boy be in the hospital? The doctor said 3 or 4 days, not over 4. Then the boy can come home, and it will be just a few days. He will go back to work with a good hand. Okay. Now, is that a promise? Meaning, is that a promise the doctor's made that if the boy is not at home within 4 days, okay, is that a breach of contract? What do you think? Mark.
No. I would say that the doctor's guaranteed, because it was a verbal agreement between both him and the father, there should be some type of they should have some type of consideration into that account, because he clearly stated, yeah, he'll be good to work after 3 to 4 days. So
okay,
if it goes past 4 days,
would you think, Mark, that this is more akin to, I promise you that he'll be done after 4 days and be able to go to work with a good hand? It's more like that, and not as much as I think he may be done after 4 days and be able to go back to work. And what is the difference between those two things?
I think, well, from the language of the doctor, he says 3 or 4 days, not over 4. So he's guaranteeing that it won't be over 4 days. So I would say that he's guaranteeing the patient's father that it will be working fully after 4 days. And
So
I
in your
think-
mind, if it takes over 4 days, that's a breach of contract, right?
yeah, because he's guaranteeing that he can go home and he'll be able to use it properly.
Okay, thank you. Who disagrees with that? Who thinks it's not an actual objective manifestation of a promise and it might be something else? And what would that something else be?
You have Ed has his hand up.
Ed, could you
Yes.
illuminate?
I would argue that's more of a doctor's observation based on the given fact. Although he's giving a good faith standard, saying that, okay, from a doctor's perspective, 3-4 days is optimistic of getting his hand recovered, but there's no guarantee. There's a lot of unforeseeable factors that can contribute to a longer delay. So it's just a doctor kind of giving hope to the patient.
Okay, so doctor giving hope to a patient. I'm an objective person. Hearing that wouldn't say the doctor is making this promise. The doctor simply giving an opinion. Okay. Now, do you see the difference in those two things is really important? Because on the one hand, if it's a promise that's exchanged for the other person's consideration, money or something like that, then it could be breach of contract. If it's simply an opinion, right, then we're not talking about breach of contract. We're talking about simply a doctor giving an opinion. Okay. Now, how does that differ from what else the doctor says?
Professor
What else is it?
Atkinson, you have Naomi with her hand up.
I'm sorry, who? Naomi,
Naomi?
please tell me. Naomi, please.
Yeah. Oh, thank you, Professor. Thank you, Diane. Oh, I was just going to say, based on your last question, my understanding of breach of contract, I mean, if we look at the word contract documentation, means that something really has to be documented to be a breach. Is this correct? Again, I agree with the last comment that verbalizing something, again, only stands as an opinion, but it's not a statement that I signed that I was going to be well exactly in 4 days.
Good question. Did you know, for the most part, oral contracts, if they can be proven by witnesses or other methods, they're just as effective and enforceable as written contracts. There are only certain contracts that need to be evidenced by writing, and those are specified in something called the statute of frauds, right? So for something like this, a service that's not going to take a year or longer, it actually does not need to be evidenced by a writing, even though you prefer a writing, right? But it does not need to be evidenced by a writing. It can be enforceable if a judge or a jury believes that you actually entered into a contract like this. So if we have an exchange of promises, I promise this, and I promise to give you a surgery and to make your hand 100% better, and in exchange you promise money, we have an enforceable contract there. Now it's proving the terms that might be an issue afterwards, as you're saying, and that's what we're trying to do here, is kind of look to see what these terms would be. So the judge in this case, if you see when they talked about the 4 days, the judge says clearly this is an expression of an opinion, and I hope that you see that it's not clearly an expression of opinion. It could be or it couldn't be, right? But it's not clear to me exactly if this is an expression of opinion or a promise, right? But I think you can differentiate this from the next statement. I wish I could write this for you, from the next statement that the doctor makes. And what is that statement the doctor makes that would be different in this case?
Professor Atkinson, I also want to bring to your attention, Juliana says the 4-day hospital stay is likely dictated by hospital and insurance limitations. The stay could have been longer had complications developed in the chat. And then you also have a hand raised by Mark.
Okay, now remember, I know that there's a lot of different insurance law things that get involved in here, but when you deal with contracts, and I explained this kind of on your first week as we're going through, we're looking at specifically just contract law, right? So we're not taking into consideration anything else. It's simply, is this contract enforceable? We go over the building blocks of contracts. So contract law would be something different from the insurance. Now, sometimes there's a contract with the insurance company and the provider that dictates what can happen. But this, if you see the date of this case is 1929, right? So this is probably pre-insurance, those types of things. So we're just looking at this specific contract by itself. Okay, now Mark, can you tell me why the next language that I'm going to talk about, when the doctor promises 100% the hand will be okay, is different from an opinion?
Oh yeah. So for two things. One, the doctor is a professional with a license. He's going into a contract with with one of his patients, and the thing that he says is, "I will guarantee to make the hand 100% perfect hand or 100% good hand." The problem with that statement is, objectively, what is his interpretation of a good hand, and what's the patient's interpretation of a good hand? That's where the idea of the contract, would it be breached from the doctor's opinion or from the patient's opinion?
Good, Mark. Now, how should we interpret what was said? Who should be the person interpreting what was said? The person saying it or the person receiving it?
Well, the person receiving it should be the one interpreting what the person's saying it. So
According to what standard?
I think it's just, when you're going into a contract, the person who's actually receiving the statement, like I think we were talking about this when you're talking about the car, you're not thinking, it's not what you're thinking, it's what you're verbally saying. What you say is what the person's going to interpret.
Is
So
what the person is going to hear. And I think Naomi wants to add to this,
Yeah.
right, Naomi?
Yeah, I'm sorry about the clap sign. I typed it wrong. I meant
You
to
were
say
happy
raise my
about
hand.
what Mark said. It's perfect.
Well, I was just, I'm thinking that the person that needs to interpret it is the professional, because what I'm wondering is, with these oral agreements or what have you, does the setting and what makes it a formal like oral contract, let's say, like you mentioned, Professor, certain parties, witnesses must be there to make it official. So does
Not
the
necessarily. So it can
Okay.
just be, you and I could say, look, Naomi, I promise to sell you my car for $100. And you say,
Mhm.
yes, I accept to buy your car for $100. It could just be you and me, right?
Okay. Mhm.
Now, this is something that's under a piece of a car that's under $500. So it's not, there's no requirement that it be
Mhm.
evidenced by writing. So what would you do is you would say, I didn't make a contract. And I said, yes, you did, you promised. And so we would go before a fact finder, before a judge, and you and I would plead our case. And the judge might say, look, I don't have enough evidence here. Or the judge might say, look, I believe Justin, or look, I believe Naomi, right? But there's no real need to have a formalized written contract in that circumstance. If the car was over $500, then yes, there would need to be a written contract, right? But again, think about this. It's the objective person standard, okay? So it's the person receiving that communication objectively, okay? A reasonable person, what would they believe, okay? So even here, if you were a doctor, we're in front of you, okay? A doctor says, I promise to make this your hand 100% better, 100% usable, right? Would you think that would be an opinion, or do you think that's a promise that could be a contractual liability if it's not 100% useful, and why? Yes, Kaylee, please.
I feel like the word guarantee is really strong. Like that's like, I promise, like no doubt about this is gonna happen. I guarantee it.
I guarantee is pretty strong word, right? If you're a doctor, be careful saying I guarantee something, and doctors generally don't say those types of things, right? All right, Ed, what do you have to say?
A point of guarantee versus when a doctor's trying to get, I hate to use this word, but trying to make a pitch for the customer or for the patient, because you have the choice to go to any doctor. So obviously a doctor is going to make a strong case to render service for it. So how would the tone of that language work in the sense of a contract?
Okay, good. I mean, you have to have maybe understanding how the communication happened. Do we have any indication of how the communication happened? Somebody mentioned this earlier. Was it Sarah? I think Sarah mentioned this, that she knew what happened during that communication. Am I right, Sarah? Am I calling on you? Okay. I think I got you on mute.
I raised my hand and I didn't mean to do that. Yeah, it sounded like there was a conversation between the patient, the father, and the physician. That the physician was actually reaching out to them, soliciting for business because it's 1929. He's wanting to experiment on skin grafting, so he's actually reaching out to the patient. And it sounded like there was a verbal exchange. Of course, the doctor kind of disagrees with that, but that was my takeaway from it. And I also wonder too, does the argument come into play of, that his hand was worse off, that we would expect his hand to be in better condition, at least minimum objectively, after he comes out of surgery?
So we're right now we're establishing kind of what the terms are, right? Because if once we establish terms, we can establish where there's a breach. And once there's a breach, then we can talk about what you're getting at and what the damages should be, right? And so I agree with you. I think that the fact that this doctor was soliciting, the fact the doctor said, hey, look, come with me 100, I guarantee 100%. I think that's part of the contractual term, right? I think that whether it's oral or written, I think that's part of the contractual term. And did we get that? We did not get that, right? We got a promise 100% usable hand, and we get a hairy hand that's unsightly and unusable. And if you read about this case, there was lots of hair growing on that hand. Okay, so
Professor
what do we do now?
Atkinson,
Yes.
you have a question from Hussam. Does signing a consent after verbal discussing it of possible complications override verbal agreement or contract?
Okay, so what you're getting at is something called contract modification that we would get into in our class, right? But right now, what we're discussing is simply, we're going to discuss what remedies are, in this small class. We're discussing kind of one of the building blocks, the promise for a promise of what a contract is, right? But this would be something about, would it override? It depends. If it's a subsequent contract, yes, it would override, but it depends, and something that we would discuss at length in a contract course, right? Okay, so now let's say you are the person with the hairy hand, okay? And you sue the doctor, okay? You win for breach of contract. What should we give you as damages? What should your damages be? I mean, what could remedies? Let's talk about possible contract remedies. What are possible contract remedies? Mark.
So I think one of the things that we could that they could ask for remedy is because he wasn't able to go to work properly, he would be given back the time that he missed from work due to the complications with his hand, and also if there are any other like medications or anything afterwards, that they would pay for all those medical bills as well.
So missed work because of the complications with his hand, okay, that'd be called, incidental damages, right? Okay, what else? Just generally speaking, let's say that my car that I'm always talking about, my car with Diane Steel. Let's say I promised my car to Diane for $1,000, right? And Diane breaches that contract, doesn't give me the $1,000. What are my contract remedies? What could we do?
Litigation costs, possibly additional surgeries.
But think about this. Before we get into the surgery, right? Think about my example. I'm going to give my car to Diane Steel for $1,000. Dan likes the car. She's going to pay me $1,000 for it. Let's say that I think, oh, I like my car too much. I'm not going to give her my car. What can Diane do? And she says, she goes to court. She finds that I'm in breach. What are her options? What could a court force me to do? Sarah, your hand up.
Pay some compensation.
Good. So we'd like to talk about compensation, right? What would be compensation here?
Probably the cost of the surgery.
So think about the car issue. So Diane's out of car, right? So think about what I promised Diane. I promised Diane a certain car, and this is much better when I can write it down, by the way. So in class, you're going to have a lot of writing. I promised Diane a car for $1,000. Her expectation, right, was that she would have that car for $1,000. So a court, what they could do is they could say, hey, we're going to force Justin to give the car over, right? But a lot of times courts don't want to force people to do stuff. So they do something else. They do something called compensatory damages, as Sarah said, right? So maybe the court would say, hey, look, that car is now worth, $1,200 on the open market, the same type of car. So they're going to say, you know what, we're going to make Justin, he promised her a car for $1,000. The same car is now $1,200. So we're going to make him pay the difference. We're going to make him give Diane $200 so she can now have that car that she wanted for $1,000, right? So this is the type of things that we're talking about. Now, going back to the hand case, right? Think about this measurement. Generally speaking, courts want to give in contract law, they want to give the difference between what was promised and what was given. So what was promised, now that we know? Back to the McGee case.
Oh, a hand that works at 100%.
A hand that works at 100%, right? Okay, what was given? A hairy hand, okay? So what would we need to do, figure out?
They'd have to figure out how to get the plaintiff's hand to 100% with it not being hairy. So that plus whatever additional fees that are needed to fix that, I guess.
Okay, so a couple things. Maybe they could pay for another surgery, but let's say in this circumstance, it wasn't, you can't do that. So we've got a hairy hand and we have the difference between a hairy hand and the difference between a 100% perfect hand. So what we're going to do is we're going to say we have to come up with some sort of number, everybody. Some sort of number that's going to compensate this person. We got to figure out what the difference is between a working hand is and the hand that he has is, right?
Right.
To figure out what that is. So how would we do that?
Professor Atkinson, you
Yes.
have somebody in the chat saying refund back fees of surgery. You also have someone saying pain and suffering. And you also have Naomi with her hand up and now Sarah with her hand up.
Okay, so let's go. Naomi, tell me.
So, so yeah, that was a good example with like the car
Yeah.
situation. Typically doesn't let's say the patient need to go for like an assessment with another doctor to precisely see what is needed. Like, let's say in this case, to treat that extensive growing hair, because I mean, the hand could be halfway there or more than halfway treated. It's just that there was like a glitch, let's say, that caused the hair. And maybe that's the compensation that, you know, we need to focus on.
Good, Naomi. What you're thinking about this correctly. You're thinking we need to get whatever it costs. We need to get this person from hairy hand to good hand, right? Somehow, whatever that monetary cost is. Even if we can't fix the hand, there's got to be some sort of numerical value, for example. That would be the best. The numerical value is another surgery that this prior surgeon could pay to take care of those damages. And again, those are called expectation damages. You promised me something, right? And I was delivered this, and we want to give the difference of those things. Okay. Now, and so that's generally how it works with like you're promised a car, right? A car that's supposed to do certain things. Like you're promised a car with automatic pilot, right? And you end up with a car with no automatic pilot. So what would be your damages? It'd be like, okay, you're gonna pay me the difference between what a car costs with automatic pilot and what it costs without automatic pilot. And that's the difference. And I can use that to then put automatic pilot in my car or do something else with it, right? It's about what I was expecting, expectation. That is what contracts we like. We like to put people in the position they would be if the contract were performed correctly, okay? We want to try to get them as best we can. Now, what about pain and suffering here, okay? Pain and suffering from the surgery, okay? If we're talking expectation damages, okay, now everyone think about this again. So expectation damages, right? We're looking at putting McGee in the place he'd be if the surgery would have been done correctly. So we're trying to do that. And the way we do that is compensate him, okay, for the difference between a good hand and a not good hand. Okay, good. Does pain and suffering come into that? Do we, if we're looking at that as the damage measure, do we also give pain and suffering from the surgery itself?
I think it really depends.
Why?
Because the surgery was to correct a problem, which was some problem that, you know, the patient had with the hand, to bring it to that 100% functioning that was guaranteed, seriously verbalized by the professional. The pain and suffering, the way I understand it is coming from what this error, which in this case would be the growing hair, this malfunction resulted. So I think the court would probably, of course, and I could be very wrong, but the court would look at what is the pain and suffering, if there is, due to the error that was brought on, not the actual surgery, the initial intent.
So from the initial surgery, this is the pain and suffering I'm talking about. If we're giving expectation damages, right? Meaning that we're going to give the difference between a good hand and a bad hand, okay? Are we going to give the plaintiff some sort of money for the pain and suffering he suffered during the surgery?
Wouldn't that be tough, because you have to differentiate between the pain and suffering that he would have happened anyway because of the surgery?
Brian, you're right, had he had the perfect surgery done, he would still have what?
Pain and suffering.
Pain and suffering. So the pain and suffering is the same when you're dealing with expectation damages, right? Like that's kind of like the cost that he put in, like the payment that he put in to end up having a good hand. So whether the surgery was performed correctly or not, right? He would have still had the pain and suffering. So yeah, that would not be included in that expectation measure.
You have a question,
Yeah.
Professor Atkinson, from Juliana. What would fall under malpractice? And then also Kaylee has her hand up.
Okay, so there are a couple of things. So in both of these cases that I gave you, we're only going to be able to get through this one today. The doctor was sued in what's called contract and tort. And in both these cases, the tort section, the malpractice section failed, right? So in malpractice, it would be that the doctor, there's a certain level of performance the doctor has to be at. And if he's not there, he falls below the standard of care and you can sue him in negligence. And in both these cases, those failed. They said the doctor wasn't negligent, basically. So we're out of malpractice, that realm, okay? We're simply in the contract realm, where these doctors have actually, promised to do something in exchange for money. And so we're seeing if there is actually a breach of contract. All right, so Kaylee.
I was wondering if he could actually sue for pain and suffering, because he told him that it'd be 3 or 4 days and then he'd be able to go back to work. And since he wasn't able to go back to work and he suffered from not being able to go back to work and loss of income, couldn't he sue for that?
What would that depend on from what we talked about earlier?
So that was kind of what I thought when it comes to that, mistake. I mean, a different result came out of that. So that's kind of along the lines of what Kaylee said. If that person was really, really disabled and just couldn't do anything more because of that hair, couldn't even show it in public. That is what I meant by pain and suffering, not from the original intent.
Yeah, good. So excellent. Yeah, part of the expectation measurement, Naomi, part of that good hand versus bad hand, that's going to include all the money that it's going to take to compensate me for when I know I can't work, right? That's part of expectation damage. What's not part of expectation damage is the pain and suffering of the surgery itself, right? Because I would have to go through that anyway to get to the point where I have this good hand.
Right.
Now, Kaylee, whether or not he could be, the doctor could be in breach of contract for going over the 4 days depends specifically if that's a part of the contract, right? Which the judge here said here, clearly that's not a term of the contract. Clearly he was expressing his opinion, right? Now, but that's a good question. Okay, now the expectation measurement is the preferred measurement in contract law. Okay, there's also something called the reliance measurement. And again, I wish I had you all in class and I wish I had my board in front of me because I had all these things to write down for you, but we're going to try it this way. Okay. Now, the reliance measurement is this. We're simply trying to put the aggrieved party, the plaintiff, okay, in the position he or she would have been if the contract were never made, okay? So expectation is putting them in the position had the contract gone through. And most of the time, you get more money, more damages that way, right? Had the contract gone through, I would have been in this place that I expected, and we're going to put you at that position. Sometimes, though, it makes sense to say, okay, we're going to give you the reliance measurement, and that's not the expectation. The reliance measurement is simply where you would have been if you had never contracted in the first place, right? So in this case, what would the reliance measurement be, do you think, as opposed to the expectation measurement?
It would be whether or not if he had this surgery, would he have been able to do all the things regularly? So if he didn't get the surgery, would he still be able to use his hand to a certain degree? And if he didn't get the surgery, would he not have been able to use it? So like if he didn't get that surgery, like is his hand useless, pretty much, I was trying to say.
So how do we compensate for that? What types of things do we compensate for now? So we'll say we want to try to get him in terms of money, in terms whatever it takes to, as if he never had met the doctor before. So now what does he get? In reliance on the surgery, what did he go through? He paid money, right? We'll give him back that. In reliance on the surgery, what did he do? He suffered pain and suffering during the surgeries, right? So we're not an expectation measurement anymore. To try to get him back as if he's never met the doctor, we would have to compensate for the pain and suffering that he had during those surgeries now. Now, do you see how that's different in reliance versus expectation? To get the expectation, he would have had to gone through the pain and suffering anyway to get to that measurement of having him a good hand, right? This measurement is simply putting him in the position he would have been had he never met the doctor, right? Which is giving him money for pain and suffering he suffered during the surgery, pain and suffering that he'll suffer the rest of his life, giving the doctor's fees back, those types of things, right? Okay. Now, what questions do you have so far?
Ed has his hand up.
Ed, please.
So how would the courts, what factors would they use to determine if it's going to be a reliance factor or an expectation factor, past or present? How would they determine that?
Good question. A lot of times it's the plaintiff who pushes the remedy that they want. So in this case, for me, it might be too hard to figure out the difference between a good hand and a bad hand, right? And how much pain and suffering that's going to cause. So I don't know if I would go that way. I would go reliance measurement myself. I would push that because you get the pain and suffering of the surgery and you get the remaining pain and suffering that will suffer for the rest of their lives. So you're not taking into account good versus bad. You're just like, you caused this pain and I have all this pain now. I need to get back to the way that I was. So it's all about generally what a plaintiff pushes under the law, of course. Naomi, please.
Yeah, thank you. So my question then becomes, the plaintiff needs to receive counsel. How does the legal professional differentiate between like saying, oh yes, we should go, the expectation or the reliance? Because you don't want to come to court and just be totally outrageous off the charts. And we see that all the time.
It's all with when you get counsel will advise you on what the best method going forward is. And so it's all about, your meeting with your counsel.
Okay.
So what other questions?
Professor Atkinson,
Yes.
Sarah Davy says, is pain and suffering the same as emotional distress?
Pain and suffering, generally speaking, is physical pain. And emotional distress is emotional pain, but for the most part, in modern day parlance, pain and suffering does include mental anguish as well. Good question. So, first day of contracts, you'll come in there, I'll have a case for you, and we'll start talking about the basic building blocks of contracts, right? And I always hear students say, well, I deal with contracts, I'm a contracts administrator, I deal with, 80-page contracts all of the time, right? And I always say, just because the contract is longer doesn't mean that it's valid, okay? There's certain basic building blocks of a contract. And those start with like an offer and an acceptance, right? So we'll start and I'll give you an example, okay? If I make an offer again for a car, for example. Diane, would you like to buy my car? Say yes.
Yes, I'd love to buy your car.
Is there a contract there?
Verbal.
Why not, Diane? Why is there not a contract there?
Let's see. Maybe no exchange of money or
no
yeah.
promise of an exchange of money, right?
Mhm.
Someone says no offer. Sarah, what do you mean there's no offer?
There's no agreement on exchange of funds or,
What's missing? So what are you getting at? What's missing from there? What's wrong with that offer that I
The
made?
amount of the sale of the car or the purchase of the car?
So it's missing stuff. What is it missing? No criteria governing the transaction. Great. So to be a real offer, I have to have enough in there, right? Enough of the terms in there, like price, timing, those types of stuff, which identify the car, right? And the most important thing is there has to be enough in there objectively that someone receiving that objective manifestation would think, hey, you know what, this person, there's enough in there that if I just say yes, we have a deal, right? So that'd be different from, Sarah, I have a 1992 Volkswagen Jetta. I want to sell that to you for $500. Do you accept? She doesn't. Okay, good. This is a fake one. Just accept, right? So we start with these basic building blocks. And what happens is that you'll soon realize that some large organizations are skipping over these things, and so these basic building blocks that we're talking about. And or things like when I make an offer like that and Sarah comes back and says, no, I'll pay $200 for it, kind of changes that offer, right? And what that does. But what I want to describe for you is that all of us, all of you, make contracts on a daily basis. Walking in and buying bananas at a supermarket is contractual in nature. Getting a haircut is contracts. Clicking your life away for iTunes, those are contracts, right? So I think that it's a very interesting course, and it gives you, one thing that students say a lot is that it's very practical in nature, and they were surprised that they were using contract law more than any other law as they were learning about it. So looking forward to seeing all of you, and I'm glad I got to teach this class. I'm sorry that my white pad didn't work. It would have been much better, but I appreciate it anyway. So thank you, Diane.
Yes, thank you, Professor Atkinson. Thank you for joining us. So we will go ahead and sign off with Professor Atkinson, and Professor Atkinson, again, for any of you that joined the call late, he is not only our professor of contracts, he's also our academic dean. So we're super excited to have you all meet Professor Atkinson today. And thank you so much for joining us, Professor Atkinson. And
Thank
I
you,
will remain
everybody.
on the call. Bye-bye. All right, so there you go. That was a little taste of what law school is like. And I'm happy that you all got to meet Professor Atkinson. He is beloved by our students as a professor who really cares about his students and is very engaged. It's exciting to see all of you have the courage to speak up and participate in class. One thing that and let's see, Francisco Rosas, feel free to turn your camera on as well. But one thing that's really exciting to hear from students is this level of engagement and the social capital, the networks, the connections they make with people, professors, each other in law school. It really just opens up a tremendous amount of doors for them. Your career is going to be, expanded to such a diverse amount of opportunities once you have your Juris Doctor degree. And the exciting thing to me is not only are you going to be so employable by so many different government entities, or you can become an immigration attorney or a entertainment attorney or a child advocacy attorney or in-house counsel for a large hospital, you also continue to reserve the right to become self-employed. So that is just a very powerful degree to have, one that makes you so hireable for so many diverse career opportunities, but then also one that allows you to become self-employed. So I want to just broaden it now to open up questions. You're welcome to turn on your videos if you like. We also have on our call one of our students, Gurjot Brar. I welcome you to turn on your video. I welcome Gurjot, nice to see you. Gurjot, I think, remind me, what year are you now?
I am in third year right now.
Third year, okay. So Gurjot just finished his first and second year, and now he's in his third year of law school. So if anybody has any questions for a currently enrolled student or myself or Francisco Rosas, we're happy to help. And you could just ask, you don't have to wait till we call on you. No, there's no dumb questions. So feel free, if you have any questions, we're happy to help.
I have a quick question. Are you anticipating now that COVID is kind of fading away, it looks like you're going to be having in-class versus Zoom?
Yes, absolutely, Sebastian. Thank you for bringing that up. We are fully committed to go back into in-person classes. Of course, we are doing what's most safe for our students and for our institution. So we are going to follow the direction of the CDC and OSHA and so forth, but it is our full commitment and desire to come back into in-person classes. Absolutely. And especially for our first year law school students, that's our biggest priority, is for what we first year law school students are referred to as 1Ls. And it's our first priority to launch this fall that starts August 9th with in-person classes.
Definitely, and I think just to kind of go back off on that, right? We all heard Dean Atkinson talk about, right, the in-person experience. So I've actually had the pleasure also to sit in classes, and there, it's a different dynamic, right? Obviously, we're doing this because of COVID, but hopefully, you know, when we come back, you'll feel that dynamic. You get to exchange ideas in person, and not have to talk over each other. So definitely committed to safety first, right, and then to also hopefully getting makes us a lot different, because we do have the ability of just bringing everybody back when we do have that, and get to interact with one another.
Thank you, Francisco. So Gurjot, while we have you on the call, and while people are thinking of any other questions they might have, would you mind sharing with us what is something that you liked best about the law school? What's something that stood out to you that you found you were pleasantly surprised when you became a student at San Joaquin College of Law?
Yes, Deanna, thank you. So SJCL, the reason I chose SJCL, I got admitted into other schools also. The reason I chose SJCL because they have immigration clinic. And once I was in law school, the professors are so helpful. Like they will spend like hours with you. Like if you don't understand any concept, they will spend like time with you. They will do whatever it takes if student is ready. So what I would suggest, in first year, study as hard as you can, because first year is the hardest. I think most of the students don't make it to the second year. But according to my understanding, if you can pass your first year, then there are 90 to 95% chances that you can pass your second, third, and fourth year. So first year is the hardest, and everything is on table. So I would say study as hard as you can in first year. And I studied like 6 hours, 8 hours in a day, and I got good grades. So that's what I would say, that put everything on table in first year.
Awesome, Gurjot. Thank you for that. We have a question in the chat for you. Did you work while in law school? And then we also have Naomi has her hand up, and Ed, so we'll come back to you. But first of all, Gurjot, can you comment about working in law school? I know you did at times, and then other times you didn't. So could you comment about that some more?
Okay, so okay, let me tell you myself what I was thinking. In my first year, I was scared that I spoke to people. They were saying that the first year is the hardest, like half of the class like don't make it to the second year and all that. I was scared that, okay, so what I thought, I will not do any job in first year. So I was like, okay, once I finish my first year, then in my second year, I can do my job. But let me make things clear. One of my friend, she was working full time and she was going to law school, and she got really good grades, like above 80%. So I am not saying that if you are doing job, you cannot do law school. You can, but you have to put efforts. It's like 2 jobs, like 8 hour you're like that job and 8 hour this job. So you cannot take this law school as a part-time. Okay, this is a part-time. No, you cannot. You have to put 8 hours, 6 hours, 8 hours, depending on the day, depending on the class. You have to put effort.
Awesome. Thank you, Gurjot. Yeah, I hear you that you can't see it as something part-time. You want to put all of your 100% effort into it to be successful. Naomi, you have a question.
Yeah, just a quick question on the LSAT. Does the college have any kind of preparation courses?
Yeah, I'm going to let Francisco respond to that.
Yeah, we actually do. So we have the LSAT nights. It's an LSAT forum. It's done the night. Right now we're doing it via Zoom. And the next one, it's actually coming up on June 23rd. You could already go onto our website at SJCL and register for it under events. It's a great night. The outside, right? I don't know if you kind of looked into it or not yet, but it's based on 3 sections: reading comprehension, and there's analytical thinking and logical reasoning. All right. We don't do the logical reasoning or the reading comprehension because that's a little bit too much for one night. But the critical thinking, which is where they take the games, right? We do that. So we'll send actual problems that have been on the LSAT, and the professor will teach you how to prepare for those games there. So we do have those free courses. We do them probably like once every month. They're great. I actually started doing them myself, and probably like on the 5th time of going to the same class, it kind of clicked on me. And so I suggest you do more than once. And then there's also the free material at the LSAC website under the Khan Academy. It's completely free also to study there as well.
Awesome. Thank you, Francisco. Thank you,
Francisco. Thank you.
Also, there are other paid courses.
Thank you, Gurjot.
Or
Sebastian, hold on 1 minute. Ed, you had your hand up.
Oh, I'm sorry.
That's all right.
Yes. So back to so my question is 1L, particularly your first semester is the toughest to get adjusted. What are some of the attributes of a successful student, and what are some of the pitfalls that lack of experience per se that you see students kind of falling and not being so successful? So what should we encourage and what should we avoid as a 1L?
Awesome question. So you want to know the attributes of a student, and I'm gonna and then what are the pitfalls? So I'm gonna turn that over in a minute to Gurjot, but I do want to say, when you are writing your personal statement, this is exactly, I'm glad you bring this question up, Ed. This is exactly what they're looking for, are the attributes that are looked at for someone who's successful in law school is perseverance, determination, follow through, work ethic. Those are the attributes that are going to show that you're going to be successful in law school. So if there's any way you can communicate that in your personal statement, that is very helpful in terms of admissions. But Gurjot, what are your comments in terms of attributes and pitfalls?
So like I mentioned, like in first year, in first semester, we don't know how to study, like how to make notes. We know nothing. So that's the point. So we have to spend more time because in my first year, I was a mess. Like I will tell you, I'm telling you the truth that I was a mess. I was studying all these supplements. I was making notes from professor. I was talking to professors. I was looking at all these supplements, all the like online resources, all the books. But like after first year, I realized that I don't have to do all that stuff, because that's the whole point. In second year, you know, okay, like this is what works for you. This did not work for you. This is how you can study. So that's why you have to put more effort in first year. And the second thing is, in first year, in first semester, you should study each day. Don't wait for finals that, oh, finals will come, only then I will study. No, you have to study every day, 6 days. Maybe you can skip Sundays, 6 days, 6 hours, 5 hours, depending on your ability. Some students take 8 hours, some students take 4 hours. I take, like, I'm a medium student, 6 hours I take. So you have to figure out by yourself. And the the most important thing is you have to talk to your professors, because you talk to your professor, you tell your professor, this is where I'm lacking. Then professor can guide you accordingly. Okay, you can use that supplement, or you can do that thing. Professors have gone through all these steps, so they can guide you better. And then the fourth thing is, the good thing about SJCL, that we have organizations, we have student organizations, and once you join those organizations, we provide you with mentors. So there is one mentee, like in first year mentees, and then we have mentors, so they can guide you like how you should study and all that. So that's really helpful. That had helped me a lot.
Awesome. Thank you. Thank you so much. Those are really good suggestions, Gurjot, and I really appreciate your comments. I'm just noting that we're at our 1 o'clock hour, so I am going to stop recording here shortly, but I will remain on the call, as well as our Assistant Director of Admissions and Student Engagement, Francisco Rosas. We will remain in the call. I think Gurjot said he could stay longer as well. But I just want to bring closure to today's meeting, because I know some of you have to get back to work, and say that I'm really excited that you're interested in this career path. And as Gurjot mentioned, the faculty at our school are phenomenal. They are known to get to know you on a first name basis, and you get to know them on a first name basis. They're very approachable, but you do, as Gurjot said, you have to seek them out. You have to set up office hours with them. Don't wait for them to call on you necessarily to say, how are you doing in law school? You want to reach out to them. And if you're finding that you're distance, ask for help. Don't be shy about it. You've got to really realize this is your opportunity to engage and talk with these professors and ask questions. Also, before I close the call, I'm going to stop the recording, but we'll stay on the call. I just want Francisco to comment a little bit, as Gurjot talked about the different student organizations that are there in terms of building social capital, networking opportunities, and so forth.
Yeah, definitely. I want to actually touch on the, what do you do as a 1L? So the class that I've taken is legal methods. So the first year, every student will take legal methods, and that class is designed to help you learn how to take notes, help you learn how to read a case. Today, everybody got some case, and they'll teach you how to breathe. They'll teach you what to look for, right? So the 1Ls will all be in this class where you will learn together how to do law school, because it is not something that even myself, right, that I had ever experienced. So going through that class, I was able to understand, punitive damages and stuff like that. And it touches on the rest of the classes, which are your core classes that you will be taking, right? Like contracts. Gurjot, what are the other three for your first year? If you could please elaborate.
It's civil procedure, contract, and torts.
And would you also say that, the legal methods class kind of helped you set up for those other three?
Yes, definitely. Legal methods help you, like they tell you to make memos, like, okay, let me tell you my experience. In first year, I was not working, so I did not realize how important legal methods is. It was like Thursday, last day of the week, so I was like, okay, whatever. But when I started my job, legal methods is the most important subject, because legal method teaches you how to make memos, how to make outlines, like everything they teaches you. So that is the most important subject. So that's what I would say.
Good. Legal methods being the most important subject. Absolutely. Javier, do you have any other closing remarks before I stop recording? Okay,
yeah, definitely. So the student groups that we have on campus, right? We have SBA, which is like everybody's become part of SBA. They get elected officials and whatnot. They usually have welcome certain parties that when we come back in, and when we're also leaving for the semester. It's a good way to get a hold of people. There's several. There's about 5 of them. Legal ALSAC. And there's other Delta, Theta Phi. And the great part about organizations is that when you join these organizations, right, they have like study groups. They give you mentors, as Gurjat mentioned. So you become part of this group of individuals within those organizations, and you're able to do events together, but also learn, right, some keynote taking from the upperclassmen and whatnot. And so they're very good groups to be a part of. On top of that, right, you get to build your network. Because remember, some of them are going to be ahead of you. They'll be already in a law firm or something when they graduate past the bar. So looking for jobs and stuff like that, it's a really great way to make that connection and that networking within the institution here.
Awesome. Thank you. Thank you so much, Francisco, for sharing that about our student organizations. If you go to our website, you can find all of them listed, and it's a great way to get involved once you're a student here. So again, I'm going to go ahead and officially stop recording. Before I do that, though, I just want to thank all of you for coming. Please do reach out to myself, Diane Steel, Director of Admissions. If you have any questions, Francisco will put our emails in the chat. My email is dsteele@sjcl.edu, and Francisco Rosas is FROSAS@sjcl.edu. I am going to stop recording now, but thank you for coming, and we're going to stay on the call for any further questions.
Thank you, everybody, for being here.